Hello and welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. State of Karnataka versus T. Nasir and others. The Supreme Court, in the context of the Bangalore bomb blast case, reiterated that a certificate under Section 65B of the Indian Evidence Act can be produced at any stage of the trial, if the trial is not concluded. The court stressed that the essence of a fair trial in a criminal case goes beyond fairness to a single party. Rather, it aims to prevent the escape of the guilty and the wrongful punishment to the innocent. Further, the court emphasized that non-production of a certificate under Section 65B on an earlier occasion is a curable defect. The court referred to the Arjun Pandit Rao Khotkar case as well, wherein it was held that the certificate under Section 65B can be produced at any stage if the trial is not over, and by doing so should not result in serious or irreversible prejudice to the accused. The present case involved a series of bomb blasts in Bangalore in 2008, which prompted a scientific investigation that led to the discovery of various electronic devices. The accused contested the admission of the examination report as evidence without obtaining the certificate under Section 65B, which is a mandatory requirement. The Supreme Court heard the matter after the prosecution's application to introduce the certificate was rejected by the trial court, and the rejection was thereafter upheld by the High Court of Karnataka. The apex court asserted that permitting the production of the certificate would not cause irreparable harm to the accused, and thus allowed the appeal. The top court directed the trial court to continue with this case, emphasizing that the accused would have ample opportunity to challenge the evidence. Union of India and others versus Dillip Paul. The Supreme Court bench of the Chief Justice of India D.Y. Chandrachud, along with Justice J.B. Pardiwala and Justice Manoj Mishra, while considering a case involving allegations of sexual harassment at workplace, emphasized upon the gravity of such misconduct and underscored that it is imperative that the offence be viewed seriously and perpetrators held accountable under the law. The court acknowledged the profound impact of sexual harassment on victims and stressed on the need for a stringent approach so the harasser does not escape from the clutches of law. Concurrently, the court cautioned against the potential misuse of laws addressing sexual harassment and said that the courts have a duty to make deeper scrutiny of the evidence and decide the acceptability or otherwise of the accusations. Every care should be taken to separate the chaff from grain. The veracity and genuineness of the complaint should be scrutinized to prevent any misuse of such laudable laws enunciated for the upliftment of the society and for equal rights of people without gender discrimination by anybody under the garb of sexual harassment, lest justice rendering system would become a mockery. In the instant case, the apex court was considering an appeal by the union government against the judgment of the Guwahati High Court, which set aside the decision to withhold 50% of the pension of a senior Sahastra Seema Bal officer implicated in a sexual harassment complaint lodged by a subordinate woman officer. The High Court had identified irregularities in the disciplinary proceedings conducted in 2011, including actions exceeding the committee's mandate and a dearth of substantial evidence. The Supreme Court criticized the High Court's judgment, characterizing it as a significant error. The court expressed concern that adopting the High Court stance would diminish the role of the Complaints Committee, reducing it to a mere recorder of information. The apex court laid emphasis on Section 165 of the Indian Evidence Act and noted that the provision permits a judge to put questions to the parties or to the witnesses in order to discover or obtain proper proof of relevant facts. The Complaints Committee, after being equated with a judge in a judicial proceeding, must not be denied that privilege. In the same vein, the top court noted that there was no statutory bar nor any logic to restrict the power of the Complaints Committee to put questions to the witnesses only to the context. The apex court then allowed the appeal and nullified the order of the High Court, while also restoring the order of penalty imposed by the disciplinary committee. However, the court clarified that the appellant should refrain from recovering any amounts previously paid to the respondent. Ashini Kumar Upadhyay versus Union of India and another. The Supreme Court has issued comprehensive guidelines to expedite the resolution of criminal cases involving elected members of parliament and legislative assemblies. The three-judge bench of the Apex Court, comprising the Chief Justice of India D.Y. Chandrachud, Justice P.S. Narasimha and Justice Manoj Mishra, formulated these guidelines in pursuance of a petition filed by Ashini Kumar Upadhyay, who sought two reliefs. One was expeditious disposal of criminal case against elected members of parliament and legislative assemblies. And second was the constitutional validity of Section 8 of the Representation of People Act of 1951. The top court directed the Chief Justices of High Courts to initiate a suo motu case titled in reference Designated Courts for MPs and MLAs to oversee the prompt disposal of criminal cases against elected representatives. Initially, the Apex Court proposed 12 courts. However, after reconsideration, it suggested a designated court in each district for prioritized hearings. The information on the status of cases against MPs and MLAs was also sought from the High Courts. After analyzing the reports submitted by the amicus curiae in the case, Senior Advocate Vijay Hansaria, the court identified 5,175 pending cases as of November 2022, with 2,116 cases pending over a period of 5 years. Emphasizing the impact on political democracy, the court stressed the need for prioritized and expeditious resolution of these cases. Briefly, the guidelines are as follows. Suo motu registration of cases. Chief Justices of High Courts are directed to register suo motu cases and to monitor the early disposal of such cases. Special bench. A special bench presided by the Chief Justice or assigned by the Chief Justice will hear the cases. Prioritization of cases. The designated courts are directed to prioritize cases against MPs and MLAs, giving first priority to cases wherein punishment is death or life imprisonment, followed by cases with imprisonment of 5 or more years, and then other cases. Limiting adjournments. Trial courts are directed to limit the number of adjournments except for rare and compelling reasons. Technological advances. The principal district and sessions judge is tasked with ensuring sufficient infrastructure to enable the use of technology for effective functioning of designated courts. Monitoring and reporting. High courts are required to monitor the progress of these cases with the principal district and sessions judge responsible for providing reports at regular intervals. Transparency. High courts are directed to create a separate section on their website which would provide information about the pending cases district-wise, along with the stage of such proceedings. With this, the Supreme Court disposed of the writ petition with regards to the speedy disposal of cases. However, the issue of constitutional validity of Section 8 of the Representation of People Act will be taken up for hearing at a later stage. And with that, I am Anya Singh. Thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal updates.